After a brief stint at the bar, Justice Souza began his illustrious judicial career by becoming a magistrate at Balapitiya. He assiduously ascended the legal ladder, the judicial ladder, by becoming district judge, the High Court judge, and when he went on to appeal courts, he brought with him a great volume of learning and experience. As a judge of the High Court, Justice Souza was called upon to preside over a celebrated trial at bar. The then leader of the opposition, Ms. Amadalingam, leader to a left, was charged with offences under the emergency regulations. Mr. Pasupati, the Attorney General prosecutor, I had the privilege of being his junior. A galaxy of lawyers, led by the late G.G. Ponnarul QC, appeared for the defence. The defence took up the position that the regulations were ultra vires as there be no proper declaration of emergency. Much to our disappointment, and to the dismay of the government in power, the High Court upheld the objection and acquitted the accused. Mercifully, stalling of judges was still in the room of time, and even those of us who disagreed with the judgment admired his courage and his erudition. So that is the caliber of Justice Souza. In the appellate courts, he was drawn between his desire to preserve judicial scrutiny, judicial review, and ouster clauses. He had to grapple with reconciling the ouster clauses with his desire for judicial review to see that the rule of law was firmly established. There are two cases which come to my mind. One is the case of Somavati versus Madhavada, where the question arose as whether the finality clause in the partition law superseded the revisionary powers of the Court of Appeal. If I may explain for foreign guests, there is a clause in the partition law which says that once the court partitions a land, that decree shall be final and conclusive and shall not be questioned in the court, except for certain exceptions. 5 judges sat on the issue. Justice Souza delivered the judgment, the others agreed, and to his credit, he upheld the right to judicial review and resuscitated the rule or the notion of the fundamental rights affecting the decree, so the courts were left free to review the decree. Another challenge came in the Rashid Ali case, as to whether a right of appeal, if not exercised, precluded judicial review altogether by your revision. Again, Justice Souza, being bred in the tradition of the law, upheld the right to judicial review in exceptional circumstances. I don't want to go on and on. I will random pick of his judgments, but before I depart, may I also refer to one singular case, the Felix Dias versus the State Film Corporation case. Now that was a scintillating judgment on the content, the nature and the procedure in regard to interim injunctions. He followed it up with an article on injunctions which has been read and reread by judges and lawyers alike, and which caught the attention of no less a person than Lord Denning. Lord Denning wrote to Justice Souza, and said, if I quote, commenting on the article, he said, I congratulate you on it most sincerely. You have explained the law clearly and accurately. I would suggest that the Judge Institute procure this letter from his son, my good friend Harsh Souza, and retain it in archives, and perhaps retain it when my good friend becomes Justice Souza II. Justice Souza did not slip into a passive retirement. He continued to serve as editor-in-chief of Sri Lanka Law Reports for well over 25 years. He was the founding director of the Sri Lanka Judicial Institute. I believe Justice Wallace recounts today when the institute was set up with no doubt resistance and advice from Justice Wallace. I believe Justice Wallace was reminiscing now on those moments when the institute was set up. In fact, it is said that as director of Judicial Institute, he used to be disturbed late at night when judges poring over writing judgments when they came across a knotty problem, and he was always there to respond. He was in fact a mentor to many a judge and to many a lawyer.